Brought to you by Wall Street Prison Consultants.
Hi, I'm Olivia, a custody advisor at Wall Street Prison Consultants. Today we're going to discuss wire fraud. Wire fraud under 18 USC Section 1343 is generally described as any fraudulent activity involving the use of electronic communications. This can include wire transfers, as the name implies, fraudulent use of the internet, phone calls, text, social media, and email. Because the scope of wire fraud is so large, there isn't one typical way it happens. It can take the form of investment scams, phishing emails, and business email compromises. The four elements essential to wire fraud are: the perpetrator must have had the intention to deceive someone in order to obtain money or property. Acting on intent, the fraudster must have created or voluntarily participated in a scheme to defraud another out of money or property. Fraudulent communications by a wire or telecommunication that crossed state lines, including a bank or internet service provider. The fraudster must have actually used some form of telecommunications or interstate wire to complete the fraud. Wire fraud can only be committed by someone who knowingly acts with an intent to defraud the victim. It cannot be committed accidentally. Any crime involving fraud requires the prosecution to prove that the defendant had the specific intent to defraud. Unless the government can establish that fact, the defendant will prevail. That's why many of the most potent defenses federal wire fraud defense lawyers use relate to the defendant's state of mind. The evidence in the case may permit several different conclusions to be drawn about the defendant's state of mind at the time of the alleged acts the government claims were fraudulent. If the government cannot discount the reasonable alternative intentions the defendant may have acted under, then no conviction could be sustained. Successfully raising doubt about the singular conclusion involving the defendant's state of mind will defeat a wire fraud allegation. It is a defense against a criminal wire fraud charge if the defendant did in fact communicate false information by use of a wire to an alleged victim, but did so under the mistaken belief that the information was true or accurate. Again, a person must intend to commit fraud. If someone loses something valuable because of a misrepresentation made by the defendant, no crime occurs unless the misrepresentation was made with the specific intent to defraud the defendant. Being mistaken, misinterpreting data, or misreading the source of the information from which the misrepresentation arose is not criminal conduct. This defense relies on the defendant's utter negligence or recklessness in conducting their business affairs, which are alleged to constitute intentional fraud. An experienced wire fraud defense lawyer may either have sufficient financial expertise or may hire a forensic accountant to review the defendant's business records. They may well disclose a frequently careless system of operating that is consistent with a lack of intent to defraud. The statute of limitations applying to federal wire fraud charges is 5 years. If 5 years have elapsed from the date on which the last alleged fraudulent communication was transmitted, then the government's indictment is too late and should be dismissed. Common wire fraud schemes include investment scams, using email or phone calls to offer fraudulent investment opportunities promising high returns; business email compromise, where fraudsters gain access to an employee's email account, then use it to transfer sensitive information or funds to themselves; phishing scams, where fraudsters send fake emails appearing to be from legitimate entities to capture the victim's personal or financial information; online auction fraud, where fraudsters create fake online auction sites or item listings and collect payment from buyers, but don't deliver the auction items; identity theft, where fraudsters steal someone's social security number or bank information and use it to send money to themselves. Wire fraud is a federal crime that can result in imprisonment of up to 20 years. The exact penalties vary depending on the specific circumstances of the case. The amount of money involved, the number of victims, and the defendant's criminal history all play a role. Convictions may also include significant fines. The largest possible are $250,000 for individuals and $500,000 for organizations. Fines may be higher depending on the specific circumstances of the case. Those convicted of wire fraud may also have to pay restitution to their victims. Now, let's talk about Wall Street prison consultants. Hiring Wall Street prison consultants, when facing federal criminal charges, can provide valuable support and guidance through a complex and intimidating process, and help defendants take advantage of programs offering substantial early release. Here's why someone in this situation might consider hiring them. While there's no shortage of criminal defense attorneys to represent defendants in the courtroom, most attorneys' knowledge of custody ends at the prison gates, leaving clients to fend for themselves after the judge renders sentencing. According to legal statistics, 97% of those charged are convicted, with thousands of white-collar defendants sentenced to federal prison each year, the majority being first-time offenders clueless what to expect upon entering custody. Wall Street's services begin long before a defendant even goes inside, and continues after release. Depending on when retained, they guide clients through indictment, trial, pleas, sentencing, and prison survival all the way through supervised release. By using their services, clients develop an edge when dealing with their lawyers. Wall Street takes the mystery out of the judicial court process by educating clients with easy-to-understand step-by-step explanations on federal criminal statutes, indictments, and how it applies to them, so they can make educated decisions about their case and understand the ramifications of a criminal trial versus taking a plea agreement. As I'm sure you're aware, prisons can be dangerous places, and having knowledge about prison policies, early release programs, medical care, inmate jobs, dealing with gangs, staff interactions, and the basic politics surrounding incarceration are the keys to surviving successfully and returning home safely. Many defendants are often confused listening to lawyers, friends, and family members about what will happen to them and whether hiring a prison survival consultant is helpful at all. While others may have opinions, they are typically not qualified opinions. And once sentenced, it's the defendant's freedom and safety at stake, with everyone else's well-meaning opinions being worthless. When going to prison, knowledge is key, and hiring a prison consultant with facts instead of uninformed viewpoints can be the difference between early release and spending unnecessary time in custody. Wall Street prison consultants have detailed knowledge of both the federal legal system and the inner workings of the federal prison system. Their expertise can demystify the process for defendants and their families and help them prepare for what lies ahead, by offering strategies and advice on how to reduce sentencing length through various legal channels and inmate programs, focusing on aspects legal teams might overlook. If a prison sentence is unavoidable, Wall Street prepares defendants for the realities of prison life, teaches them survival tactics, and helps with the emotional transition from freedom to confinement, as well as securing designation to a preferred facility that meets an inmate's needs and aligns with their specific security level or health requirements. Wall Street offers support in planning for life after release, including supervised release requirements and re-entry into society, and doesn't make false promises, but provide a realistic view of the situation and what can be done to mitigate it. While they are not lawyers, they often work in conjunction with legal teams to make sure that all aspects of the defendant's situation are being considered and offer more personalized and continuous support compared to a legal team, especially during the post-trial and imprisonment stages. In essence, they can provide comprehensive support tailored to the unique needs and challenges faced by someone charged with a federal crime, and help them navigate through both the legal and prison systems. It's a specialized service that can add an extra layer of support and guidance that complements the legal defense, but doesn't replace the need for competent legal representation. For more information, contact the director and founder of Wall Street Prison Consultants, Larry Levine, at 213-948-1069, or by email at help@wallstreetprisonconsultants.com. Or visit us on the web at wallstreetprisonconsultants.com.